Good morning, Mr. Hefer. You may take off your mask because there is enough distance between you and the commissioners. Thank you.
Thank you, Chief Justice.
How are you this morning?
I'm okay, thank you.
Thank you. I wish to welcome the Judge President of the Free State, Acting Judge President. Thank you very much for joining us this morning.
Thank you, Chief Justice.
Thank you. I am advised that the Premier of the Free State is represented by the MEC for Social Development, Ms. M. Qabate. Ms. Qabate, are you there?
Morning, Chief Justice. Yes, I am in, and greetings to all.
Yes, thank you very much. You are welcome. Thank you for joining us. Okay. I want to start off, Mr. Hefer, by thanking you for availing yourself for consideration for appointment as a judge of the Free State Division. We appreciate that.
Thank you for the opportunity, Chief Justice.
Yes. I am going to ask you some questions, and after I am done, I will ask the Acting Judge President to put questions to you, and thereafter the MEC representing the Premier will do the same, and then commissioners who wish to ask you questions will then be allowed to do so after that.
Thank you.
The questions that all of us will be asking you will be aimed at satisfying ourselves how your appointment would meet the selection criteria that this commission applies when interviewing candidates, which were approved quite some time back. Those criteria include whether you are appropriately qualified, whether you are a fit and proper person, and whether your appointment would help reflect the racial and gender composition of South Africa, and whether you are a person of integrity, and whether you have the necessary energy and motivation, and whether you are a competent person, technically competent, and whether you have capacity to give expression to the values of the Constitution, and whether you are an experienced person technically, and whether you are experienced in regard to the values and needs of the community, and whether you possess the potential, you possess the appropriate potential, and what message your appointment would send to the community at large. So questions will be directed to you, aimed at satisfying ourselves how your appointment would meet those criteria.
Yes.
The questions that commissioners will put to you will be crisp, and you are urged to do your best to also give crisp answers.
I'll do so.
Okay, all right, thank you. So we'll start. I see that in terms of your qualifications, you possess or you hold a B.Juris degree, which you obtained in 1985, and an LLB degree, which you obtained in 1989. Is that correct?
That is correct, Chief Justice.
And you obtained both of them from the University of the Free State, is that right?
Yes, that is correct.
And after you had completed your B.Juris degree, but before you completed your LLB, you worked as a judge's registrar from 1986 to 1988, is that correct?
That is correct, Chief Justice.
Yes, and then you served your articles in a law firm called Jan S. de Villiers and Son in Cape Town from 1989 to 1990.
That is also correct.
And you were then admitted as an advocate in 1991, and you have been practicing as an advocate since then
That is correct, yes, Chief Justice.
in the Free State.
Yes, Chief Justice.
Yes. And that means you have been practicing for about, 31 years?
December last year was 30 years, Chief Justice.
Sorry?
December last year was 30 years.
Yes. And when did you take silk?
2018,
2018.
3 years ago.
Yes.
3 years ago, more or less 3 years ago.
Yes. Tell us about the branches of law that your practice covers. What branches of law do your matters that you deal with in practice relate to?
Chief Justice, currently it does not consist it consists of all civil fields, excluding, I would say all civil law, but it excludes employment law. I don't do any employment law at all. I don't do much administrative work. Now and then I will have a look, or might have been involved in administrative reviews, but not fully up to the end. Mostly it's commercial work and contractual matters, and eviction from property and properties in the Northern Cape. That is what my practice consists of at this stage.
And you are talking about what your practice covers now, but you can tell us also about what it has covered over the years, because there may have been some branches of law in the past in which you were involved, but you are no longer involved now.
Yes, Chief Justice. Previously, I had been doing the first approximately 8 to 10 years of my practice. I've been doing criminal work, the so-called Prodeo system, which we had many years ago, which assisted the accused or the people who could not afford legal representation. So that was mainly what my practice consisted of at that stage. Thereafter, I started doing some work mostly in the magistrate court, civil matters, which combined my practice with civil as well as criminal matters. And then on that basis, I started doing more and more civil matters, which up to at that stage, I'm not doing any criminal work for the past, I would say, 20 years.
Yes. And how much constitutional law, administrative law do you do in your practice, or have you done?
Chief Justice, not much constitutional
much.
law. No, I haven't done
Yes.
much. The same goes for administrative law.
Yes.
I have done in a lesser degree some consultations, and which often happens, but not often, but it does happen. But I haven't done much, no.
Yes. And labor?
Labor, not at all.
Not.
I tended to stay away from that because it's a specialized field, which I did not want to venture on.
Yeah. And in terms of acting, what periods have you acted in the High Court?
Chief Justice, in totality, approximately 6 months.
About 26 months?
No, 6 months, Chief Justice.
About 6 months?
6 months, yes.
Oh, okay. Would that translate into 2 terms, or it's more than 2 terms?
I would say, all in all, it would be approximately, everything together combined would be about 2 terms, yes. But it was on and off periods.
Okay.
Once was for a full term, and then the others were just, it was
Small periods
small
here and there.
periods. Yes, Chief Justice.
Okay, all right. And how have you enjoyed acting?
Chief Justice, the very first time when I was asked to act, I was very nervous, and I remember the first time when I walked into court, especially the open motion court for unopposed motions, I did not enjoy it. I was really nervous. And I remember saying to the people, instead of thanking somebody, I said, please, may they please the court, as from the bar side. So the very first time I really did not enjoy it. And but it started getting better, and that at, I think, about the second stint perhaps, I started enjoying it. I became more confident.
Yes. And you sat in both in motion court and in trials, of course.
Trials as well, and motion court, and unopposed motions and unopposed motions.
You said that in recent years in your practice you were not involved in criminal work. But when you were acting, did you sit in criminal trials by any chance?
Yes, Chief Justice, I was allocated a criminal trial in the circuit court in Harry Smith, which was a trial which ran from the beginning to start. That was
Yes.
that was the only one that was allocated to me.
Yes. During your acting stints, what kinds of branches of law did the matters you dealt with relate to?
It was
Roughly.
roughly it was RAF, one RAF matter, evictions. One was a review of the taxation. Then there was an opposed matter about costs and about the application of Rule 45, whether the process of execution is to be stayed pending an appeal. Yes, that was about it, if I can, in short.
Yes. Matters in which you have written judgments, about how many written judgments have you written during your acting stints, if you are able to give us an idea?
Chief Justice, I've counted them some time ago last year. I think it was approximately 40, if I recall correctly.
About 40?
Yes, Chief Justice.
Yes, okay. Have some of them been reported by any chance?
I believe...
And for me, reported means South African law reports and
Yes, not the one that's...
Butterworths and...
Yes, I believe the one criminal matter has been reported in the criminal law reports, Chief Justice.
How many?
One had been reported in the
Yes.
criminal law reports.
Yes, okay. And in matters in which you have appeared, which resulted in reported judgments, have you got many of those?
Only one many years ago, which was reported, if I recall, in the SCA, Chief Justice, but I'm not sure about that, but that's as far as I can recall.
Yes. Okay. Now, what is the test used to decide whether to grant interim relief?
Chief Justice, do you mean an interdict? Or
Let's say interim interdict, to be more specific.
it will be a prima facie case, whether a prima facie case exists, where there's an apprehension of harm. The balance of convenience favors the applicant, and no alternative remedy, Chief Justice.
Yes. And when it's a final interdict?
It will be the same, save for the fact that it will not be a prima facie case, but a clear right.
Yes. And when you sit on appeal and you have to consider whether to uphold a decision granted by a lower court in the exercise of a discretion. What guides you on whether to interfere or not?
Chief Justice, the main consideration will be whether the presiding officer in the court or quo has misdirected him or herself in the application of the law and of the facts.
And when you are sitting on appeal and you are asked to set aside factual findings of a trial court, what would guide you?
The factual findings of the trial court, Chief Justice. I would say, in which regard the court found, with regards to the credibility of the witnesses, in which regard the trial court may have made mistakes in regards to the facts which was before court.
If you are appointed, when you are sitting as a judge of the High Court, you may find yourself having to deal with matters where the constitutional validity of legislation is challenged.
Yes.
You have indicated that you haven't had much of constitutional law cases to deal with. Did I understand you correctly?
That is correct, Chief Justice.
What can you say to the commissioners with regard to how you would handle such a matter, seeing that you haven't had this opportunity?
Chief Justice, I'm not making excuses, but first of all, I think in the Free State, especially in Bloemfontein, there is not that many constitutional matters which comes across in that division as such. But I will deal with the matters as far as my knowledge of the Constitution is concerned up to this far. And I will deal with constitutional matters as I would deal with any other matter which I'm not very familiar with, and go and study the principles of the Constitution and the applications as contained in the Bill of Rights, etc., in the Constitution, and then I will apply them. But I will make sure, as I say, with all, because they are very, very. I think for every presiding judge, there are very often fields or laws which are not applicable very often, and which are not worked with on a frequent basis by a certain judge or division. So I will fully acquaint myself with the principles again, as contained in the Constitution, and see in which regard the values are being protected as far as that particular matter is concerned.
You may not have been dealing with constitutional cases, and I think you said administrative law matters as well.
Yes, you said.
In your practice, but have you been taking the trouble to read and try and keep yourself up to date about the developments in those branches of law? I
have, especially in constitutional law, Chief Justice, not only for being here today, but also in general. I thought it'd be appropriate. It's in the interest of my practice as such, also to be up to date with constitutional matters. So sometimes I read some articles about the constitutional law. Of course, the matters as we find in constitutional court as such in the SA law reports, I studied them as well. So I try to far as possible to keep up to date with the principles of the constitutional law and other branches of law which I consider to be applicable in my practice, or might be applicable in practice and in future.
Yes. Thank you. I'm now going to give the acting JP the opportunity to put questions to you. Acting JP, the commissioners have agreed to limit themselves in terms of the questions to 2 questions, but we give the JP or acting JP a little bit more leeway because he or she would know the division and the candidate. So I'll give you a little bit of more leeway. You can start.
Thank you, Chief Justice. Good morning, Mr. Hefer.
Good morning, JP.
You've already indicated that all in all, you've acted for a period of about 6 months in the Free State High Court.
That is correct.
During this period, how many times did you do motion court?
You meaning by unopposed motions?
Yes, unopposed motion.
If I recall correctly, I think it was 3 or 4 times.
How many times?
3 or 4 times in the unopposed motions.
In view of the fact that in the Free State, a judge doing unopposed motion does urgent matters on the same week and all chamber work, how did you find your experience while dealing with the unopposed motion in those 3 times that you have dealt with unopposed?
If I understand the question correctly, there was how did I deal with the urgent matters?
Yeah, how did you find that experience?
Well, it was sort of, if I may say so, it was sort of exciting sometimes to receive an urgent application, and because it's sort of out of the ordinary from the matters which you found in the unopposed motions, which is a long roll most of the times. But I didn't find it inconvenient or anything of that. That's in that sense, if I understand your question correctly.
Thank you. At the time of completing your questionnaire, you've indicated that you have 1 partly heard matter. Has that matter been finalized?
It has been finalized and judgment has been delivered yesterday, Judge President.
Thank you. Thank you, Chief Justice.
Thank you, AJP. The MEC Kabata, I now give you an opportunity to put questions to the candidate. That is if you have any. That is if you have any.
I do.
Yeah.
I do.
Yes.
Chief Justice, thank you very much. And I hear you saying you have discussed with the commissioners and have agreed to 2 questions. I have 3 questions. Can I be allowed to ask?
That's fine, yeah.
Questions?
Yeah, that's fine.
Okay. Thank you. Advocate Hefer,
Commissioner.
my first question to you will be, what is your view about gender equity? According to you, is the pace of addressing gender equity within the judiciary satisfactory according to you? And if not, what plans and strategies will you put in place to address the challenge? Should a woman be a preferred candidate, will you embrace the decision or will you blame it on gender equity? My third question.
I'm sorry, MEC. Let him answer the first question and then you can put the second one.
Okay.
Thank you, Chief Justice. Thank you, Commissioner. Commissioner, I think the whole process, if I can use a word which is going to come up again, the question of transformation, especially in regards to gender, is an ongoing process which started, I think, many years ago, just since '94 perhaps, and then it gained momentum over the years. To answer your question whether it should be improved in future, I think definitely so. But I must say, I think, especially if I look at the division in the Free State, As far as the bench is concerned, and I can also say as far as the Free State Society of Advocacy is concerned, there has been a vast improvement as far as transformation is concerned, especially in regards to the female members, as far as members in the bar again, and as members on the bench is concerned. Yes, indeed, and as I say, the process of transformation should continue if one is confronted with the fact that you are, as in my case, for instance, that you must choose whether a white male should be appointed or not. With respect, one should also consider the merits, as in any other application. And if that particular applicant's qualifications adhere to the requirements or the guidelines in regards to what was being set out, what is being considered by this commission, then with respect, that should be considered favorably. If there is not a female, in particular in regards to gender, a female candidate who has the same qualifications and experience and skills.
Okay. Can I then proceed to ask the second question? Advocate Hefer, what will be your plans and strategies? What will you do to reduce postponements of cases, taking into account the negative bearing it has on victims and witnesses?
Commissioner, I would first of all, I would inquire and ascertain what is the reason for the postponement sought by the parties concerned in a particular trial or application. And then I will also go as far as possible in the recent matter which I was dealt with, to which the acting judge president just has been referred to. For instance, there was a request for postponement at some stage, which I denied because I thought it should have, or the matter should be finalized as soon as possible, or on the condition, of course, that you do not prejudice any one of the parties concerned. So I would ascertain as far as possible what is the reasons for the postponement, and first of all whether the postponement itself cannot be stopped, if I can call it like that, or curtailed in any manner, so that the matter can be finalized as soon as possible.
Okay, thank you very much. My last question will be on rural communities and farming communities. With the recent indabas and seminars that we have held with farming and rural communities, the outcry is that when they are having cases, particularly against their employers, they are not able to attend to their cases because they depend on their employers for transport. And deliberately, their employers will leave them behind. And their cases would therefore be thrown out of court because of their absence to attend. Whereas it was not out of their own will, it was because they were struggling with the transports to attend to the cases. What will be your plans and strategies to address that challenge? And there's a lot of outcry on it.
Commissioner, may I ask you, that will be in my capacity as a judge, if so appointed?
Yeah.
I will do everything in my powers.
I take it that you will also be playing a role in improving the services within the magistrates' offices.
Yes, indeed so. Indeed so,
Yeah.
Commissioner. As far as possible, as far as it can be within my power, I will try and arrange for transport to assist those people in the rural communities, which I think is important. So as far, I don't want to, I will not overstep my powers to say that, listen, you make an order to the effect that people should be accommodated and transported to the relevant venues, but I will do anything in my power to see whether those people can be assisted, for instance, by the police services to attend the trial, or whatever the other proceedings might be relevant.
I was asking the question based on improving either our policies or administrative processes to ensure that the farming and rural communities also are fairly represented when they are having cases.
Commissioner, then I would propose that at some stage with the Department of Employment and the other relevant departments concerned, that there might be some consideration at some stage to be built into legislation or into contracts of employment, that if the instances as in that regard should arise, for instance, where employees should attend court or other proceedings, there's an obligation on the employee to provide such transport to the employers.
Thank you very much. Thank you.
Thank you, Commissioner.
Thank you, MEC. I will now allow commissioners to ask their crisp questions. And I know that where they can ask one question, they'll ask one question. Commissioner Makwanisha.
Thank you very much, Chief Justice. I have two short questions. Good morning, Advocate Hefer.
Morning, Commissioner.
I think, let me start by commending you for being involved in the training of pupils for the past 14 years. And I think you will agree with me that training is a very important component, but training without work does not also assist. So how many black lawyers have you assisted as a senior counsel and women in your lifespan as a senior counsel?
Commissioner, since I've been appointed as senior counsel, the last 3 years ago, I've assisted 2 black women, yes, to assist me in trials and applications.
The second one is the mentoring of black lawyers. So you have said here you have only mentored 2. Would you agree that that is a very low number?
Yes, Commissioner, if I might just explain, when you get to a certain age or years of seniority, then you do not get allocated any pupils anymore. But then you still are available to be appointed as, well, not all being not appointed, but you act as a senior mentor for such a pupil. Because I was myself involved for the vocational training in the chairman, or most of the time in the chairman capacity, I didn't appoint myself. I sought help from other people, but I was still fully involved with all the pupils as a whole as well. So they were not my pupils, but if I may say so, all of them was under my guidance, if I might say so.
Thank you very much, Advocate Hefer. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Matolo Zlepu.
Thank you, Chief Justice, and good morning, Judge.
Morning, Commissioner.
Sorry, good morning, Advocate Hefer. Just a follow-up from Commissioner Mangwanishi. You say because of your seniority, you haven't had the opportunity, or you are not allocated people. What I want to find out from it, is it a fair thing that senior counsel should not have people? Because this is where the experience lies, and this is where we have to get all the experience. You are the pillars and, the brains behind the advocacy. Why shouldn't we have people? Do you think it's fair?
Commissioner, I don't think it's fair just to answer your question from the offset, but the reason for that being is that in general, I don't know at other bars, but in general, I think we all have the principle, or it happens that senior counsel does not go to court that often as junior counsel do. So you try you're not actually excluded as a senior, but the reason for that is you mostly appoint people from 5 years onwards to be mentors, assisted by senior counsel, just to give them the exposure as far as appearances in court, etc., is concerned. So that is the reason for that. So it might come across as being unfair, but it's just in the interest of pupils, which it has been done. But as such, as I say, at our bar, and I think at other societies as well, all the senior counsel are still available, if I can put it like that, to help in the pupillage as well. For the past, I think, 8 years, for instance, at the Free State Society, we had the principle that you have a junior mentor and a senior as well, and at presently it's still the same. So senior counsel is not completely excluded from being mentors.
Okay, just the second question. I still feel it's unfair. I must just say that. The second question I heard you saying that you were doing a lot of evictions. I hope there are no farm evictions involved.
They were not
Farm workers evictions. Are you doing some
No,
of them?
it was mostly it was in the Northern Cape. The one was in Kwakwa because of the illegal occupiers. We were occupying some ground of the University of the Free State, and most recently, which I was quite involved with and still is involved in a certain respect, is illegal occupiers of communities of land which had been allocated to communal groups in terms of the Act. And where mining is taking place, it's not farmers, no.
Thank you. I had a lot, Mr. Chief Justice, but I'm respecting the protocol.
I'm happy you are respecting that. we have taken 30 minutes already. Commissioner Singh.
Thank you very much, Chief Justice. Good morning. I'll take 1 minute. Good morning, Advocate Hefer.
Morning, Commissioner.
Yeah. We get comments from and feedback from law bodies, and I think it's appropriate for us to actually follow up on what they say and to put it to you as a candidate. Now, in your case, LSSA does not support your candidacy. You might have seen that. And the reason they give is your involvement, your lack of involvement in constitutional, administrative, and labor law.
Yes.
So that's one. And then Nadal, on the other hand, speaks about, also does not support your appointment because you have not shown any form, I'm quoting, of social involvement. And they also say that your appointment will not aid in making the division reflective on the demographics in the Free State. Would you like to just comment briefly on those comments? Thank you.
I've seen that, yes. Thank you, Commissioner. As far as the involvement in the community is concerned, I've been involved in community as far as possible. Not possible, but as far as the opportunity arisen over the years, I've been involved in the community. And behind the scenes, I'm also involved, which I don't, with respect, I don't always use that to say that this is what I'm doing for the benefit of the minorities or people that might need it. So in that sense, it's not. I'm not doing anything for the community at this stage. I'm still doing something, although not as a parent in previous years when I was involved at university or with NICRO, for instance. I'm not involved in organizations like that anymore. As far as the second part is concerned, and presently it is correct, the percentage is also mentioned by Nadal in regards to representation of the population in the Free State in general. I think mention is made of the 35% of the people of the bench in the Free State is currently white, which will include white females as well. The only thing I can say about that is that the basic vacancy which came about was because of the retirement of a white male judge as well, who, if I recall correctly, was appointed under the same dispensation after 1994 with the same considerations as well. If I should be appointed, that will mean that in respect of the 14 judges in the Free State, there will be 3 white male judges, 3 female white judges, and the rest is with respect to the black judges. So in that sense, the 35, I haven't worked out the percentage, being the 2 males in respect of the 14, but in submission, the 35 might come very close to the percentage of representation on the Free State bench.
Thank you, Advocate. Thank you, Chief Justice.
And thank you, Commissioner Singh. Before I go to Commissioner Nyambi, may I ask this question, Advocate Hefer?
Chief Justice.
It looks like you took silk after 26 or 27 years in practice.
Yes, Chief Justice.
That sounds to me like a very long time. I may not be up to date about how long advocates take silk, but my impression is that it's usually around 12 years to 15 years. That information might not be accurate, but 26 years, 27 years seems quite a long time. What's the explanation for that, if there is any?
Chief Justice, yes, you are perfectly right. I think especially in the old dispensation, it was indeed the average was about 12 years to take silk, which later again changed. I think the reason for that, I don't know the reason why it took so long. The thing is...
Did you want to take it?
Did I want to take it, Chief Justice?
Did you want to take silk?
I indeed wanted to take silk, but again, in the Free State, you are very wary of taking silk too fast, because I think in the Free State and also in the Northern Cape, you don't have that great number of matters, which like commercial matters or big matters, as if I can say it, SC matters, which warrants an SC that you have in other divisions. So you're very wary of being that. And even when I took silk 3 years ago, then I was very hesitant to do that as well. But the reason, because I've done it at that stage, because I noticed at some stage the only briefs I received, not the only, or the majority of briefs I received was mostly in regards to intricate matters, which warrants senior counsel, and then I made the decision. But to answer your question, I was very hesitant because I was scared.
Okay, all right. Commissioner Nyambi.
Thank you, CJ. Morning, Advocate Hefer.
Morning, Commissioner.
One question from me. As somebody that has acted in that division, what are the challenges facing the division that you think with your appointment you can be able to assist?
Commissioner, I'm not aware, if I may say so, with the challenges, from the perspectives of whilst being in a acting capacity, I could not find that there were great challenges. There might have been challenges in regards to infrastructure. Sometimes everything wasn't quite working in the chambers or at court. But the system itself, which I experienced both from the side as being in an acting capacity as well as from the bar side, there appears to be everything appears to be going well, if I may say so. So with respect, I can't say there are many challenges which I can say which need to be resolved at this stage.
In short, everything is perfect in Free State.
Perfect with respect is a very strong word, but it's working.
Thank you, Advocate Hefer. Thank you, CJ.
And thank you, Commissioner. Commissioner Schlemmer.
Thank you, CJ. Good morning, Mr. Hefer.
Good morning, Commissioner.
I was interested when you said that you read articles and stuff to get you up to date with constitutional matters, etc. And then it kind of caught my eye, And I was wondering about the fact that in some of the cases that the judgments that you attach to your application to the questionnaire, you don't refer to a single piece of authority, specifically the SB Guarantee Company case. I didn't pick up any authority that you are referring to there, not even case law, and it seems to me it dealt with independent guarantees, which is an area of the law where a lot of development is taking place and a lot of issues has arisen. How important do you feel is it to refer to authority in cases? The writing of scholarly judgments, as I call it, because in the other cases you do refer to authority quite extensively, but in this particular case, not one.
Commissioner, may I just have the opportunity to study the I don't know whether it forms part of the judgments in the bundle. I can't just recall just from name which matter was it about. Can I just have a look at it, please?
It is on page, let me just get to the page. Paginated 73.
Thank you. Just want to make sure about the bundle, Commissioner.
It's attached to your questionnaire.
Thank you. I've got it, thank you. Yes, Commissioner, if I may answer your question, this was regards to the to the summary judgment, which was the application of summary judgment. With respect, to me, it was actually clear cut what was involved, and especially in this particular matter, I had a look at the contents and the wording of the contracts concerned. I didn't deem it necessary to go into authorities, because it was, as with respect, it was quite straightforward to me. I think it's important to write scholarly judgment, yes. I think when you are, I'm not looking for excuses, again, I'm not making excuses, but when you are in acting capacity, you're very hesitant to do that in the sense that you are, I think even if you are in a permanent capacity as a junior judge, you're still learning. So it's not necessary always to, if I may say so, with respect again to all judges and to the profession, that you always have to refer to authorities to make a good impression. I think that's mostly in that regard it is the SCA and the Constitutional Court who plays a big role in that regard. But as far as is necessary, I refer to authorities and apply them, yes.
Thank you, Chief Justice. Mr. Hefer, I just think that even as in the division that you're in, it is important also that one just does do that. I mean, it is important for the parties to know if they want to appeal what you've said based on what principles you have based your judgment. So it's just something that I thought to raise with you. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Schlemmer. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Mr. Hefer.
Good morning, Commissioner.
Mr. Hefer, I followed with interest your answer to questions raised about transformation. And the one thing that you indicated was that I think you said you were satisfied that there were more efforts made to transform the Free State bar and bench, as I understood your answer?
Yes, that's correct.
Now, you see, Mr. Hefer, the discussions about transformation are best grounded in fact, so that we can assess progress from the facts. And I would like to put some facts to you and then pose some questions to you. Now, these are facts that we've gleaned from AFT members in the Free State Bar, and I just want to put it to you in terms of numbers, right? We're looking at 0 black women silks, 1 black man silk, right? 0 black women over the years of 10 years at the bar, or 10 years seniority or more, 0 women, black women. 1 black woman between 5 and 10 years, and 7 black women under the age of 5 years. Now, can you confirm that that's more or less correct?
That is more or less correct, yes. I know the total number of women is approximately 12, if I recall correctly, at this stage, yes. But as far as other statistics are concerned, it's correct. There are no black female silks at our bar.
But more importantly, besides no black female silks, which in my view is already an indictment, but besides that, I'm interested in the fact that there's 0 black women over 10 years seniority at the Free State Bar, and 1 black woman between 5 and 10.
Commissioner, if I can be frank, I think in the Free State, and the reason for that being is, I don't think in the Free State we've reached the point yet that the community, and perhaps also the lawyers as well, I beg your pardon, the attorneys as well, have enough confidence in black women. That is my perception. And there must be some way in regards to perhaps expose junior silk black women as well. Just last week when I was leaving Chambers, I had 2 very senior, 2 female members who passed exams last week, who were really, you could see that they don't know which way to go. They said, listen, we're not getting any work. And in all, there is a problem to solve that, yes. So to go beyond 5 years is difficult for them. Very, very few of them can't last 5 years financially, then they resign.
Yeah. Mr. Hefer, you're right, there certainly is a problem. And the problem was highlighted in 2018 when there were only 2 black women in the bar, at the Free State Bar, and one of them resigned very publicly. Do you recall that, Mr. Hefer?
That is Ms. Kui, if I remember correctly, Commissioner, yes.
That's correct. Ms. Kui resigned very publicly, and she openly shared her reasons for resignation.
Yes.
And she said that the Free State Bar was so hostile to black women that they didn't feel comfortable there. She also said that after 1 year, what would often happen is that women didn't find, as you said, sufficient work, black women specifically, and they dropped out after a year or 2. So in other words, you would have large numbers in intake, and through attrition, you would lose black women specifically, very rapidly after that, probably within the first year and then the second year.
Yes.
And so then the numbers that I've put to you right at the beginning, they make sense because very few women actually survive at the bar.
Yes, yes.
Now, against that background and against this big debacle that happens in 2018, where you have a black woman that's brave enough to stand on a public platform. She is one of 2 women at the bar at that stage. And she says to the world that there's a problem in the Free State and that there really is a cry for help for black women at that stage in 2018. I have to then ask you again, Mr. Hefer, what have you done in order, firstly, to make it easier for black women to stay, in other words, involving them in your work, and also to address the systemic issues that militated against black women remaining in the Free State Bar?
Commissioner, if I may say, I was sort of directly responsible, involved in regards to the Kui matter, because Ms. Kui came to see me at that stage, and she said she's unhappy about certain things. She didn't specify that at that stage. She just said she's unhappy of what she's experiencing, not as a black woman necessarily, I must say so, but as a junior which I think she was practicing at that stage about 2 years, maybe 3. And my words to her at that stage in my chambers was to the effect that she must please put it in writing so we can rectify it in future. I was actually a bit surprised when I was informed by the members of the Bar Council at that stage that she did this publicly, because that was not my intention to do it publicly. My intention was for her to show to the Bar Council and to the bar as a whole in the Free State what can be done to rectify the problems, and also to see that it doesn't happen in future. So that was my involvement as far as COO is concerned. Then she left, and then there was a debacle, and I think it also served before and was considered by the GCB at some stage, and it was clarified. But that was the origin thereof. As far as what I personally have done, when we served on the Bar Council, when I served, I resigned last year because I thought it was time for somebody else to take over in regards to vocational training. We did everything in our best, and myself, including myself, to first of all to assist or to gain new female black members in the society. And I know, for instance, our chairperson, Neil Snellenberg, he also made efforts to negotiate with the state attorney side in regards to appearances in the magistrate court for that reason, to assist all members, not only black members, but also all junior members to receive briefs. As far as possible, as far as my work allowed it, yes, I involved juniors in my work as well. As I said, it was for two black female members who assisted me to me in great regard. And as far as my work allowed it, I sought assistance from such members, yes.
I'm sorry,
Okay,
Mr.
yeah.
Chief Justice, just the last
One,
question.
okay,
and I'm
all
done.
right.
Just to come back to what you've indicated now, and this is specifically one of the complaints raised by Ms. Kui, that to the extent that the Free State Bar even did introduce measures to assist black juniors, and this is black juniors generally, not black women juniors, like, for example, the creation of a transformation fund. What soon happened after that was that there was a deliberate attempt to remove race from those initiatives. So in other words, to open those initiatives up to all juniors and not specifically direct them at black juniors and black and women juniors, despite the burning problem in the Free State. Now, that reflects your answer that you've just given now, Mr. Hefer. And I just want to understand, in terms of your own understanding of the problem and the steps you took to address the problem.
Commissioner, the steps I've taken was to well, as I say, as far as I could have input, and we also input on the Bar Council to find ways to assist the members, or the junior members, or then the female black members. We discussed it, and for instance, reference was made to the magistrate court appearances. The fund which was established, there was a meeting, if I recall correctly, and it was a majority decision not to throw this fund open to all juniors concerned. I myself, if you would permit me, I would refrain from indicating what I voted in that regard, because my bar might take me up on that. So I would refrain to say what my attitude was in that particular meeting. As I say, as far as I could, we can. Yes, and I can also say with the utmost of honesty that wherever I could, and there was a capable junior, which includes, and there were specifically 2 female black members who I recommended to firms as well, as another gentleman who started practice, a black gentleman who started practice also 2 years ago. He was for many years, he was in the employment of SARS, and I introduced him to one of the big firms, representatives of the big firms, for future purposes, if they look for somebody who might be interested in a specialist in tax matters.
Unfortunately, I have to leave it there. Thank you, Mr. Hefer. Thank you, Chief
Commissioner.
Justice.
Thank you, Commissioner Pillay. Commissioner Tsepe.
The white mask work, Chief Justice. Good morning, Advocate Hefer.
Morning, Commissioner.
I was going to ask you two questions, but I'm worried about time, so I may just, depending on how quickly you answer my next question, I may give it up. It relates to a question that was asked by Commissioner Singh, and that is the comments that we received from the law bodies. I just wanted just to be sure that you would have read all of them, because Nadel's issue wasn't just the issue of race, it was also that you have not acted enough. And given your some of the lack of experience in other areas you have, that you still require more time for acting before before the JC should consider you for appointment. I just wanted to hear your views on that, Advocate Hefer.
Commissioner, briefly, be as brief as possible. When I acted the first time I think it was for 2 weeks, somebody approached me at that stage and said, listen, then there was a vacancy available as well, and somebody approached me and said, listen, why don't you go and apply? I was very, very hesitant, but at the end of the day, I did apply for the vacancy, which I didn't make the shortlist. Through the times which I've acted since then, I've gained the confidence, and I would have not applied again if I was not confident that I think I'm up to do the job. I think in any matter or any field, it's always recommendable that you should have as much as practical experience as well, including acting as a judge, but as far as time allows it. But then the question all remains with respect, how many times must you act before it can be said that you have sufficiency? I have been asked, the last time I was asked by Judge President Musi from the Free State Bar to act, that was September last year. They first invited me or asked me to act for 2 weeks, which I could do, and then soon afterwards I was asked to serve for the whole term, but because of other commitments in trials, I was not able to do so. So it was not because of an unwillingness to do that in the first instance, and in the second instance, myself, I'm satisfied that I've gained enough experience.
Just, Chief Justice, through you, just to be clear, so you're saying, despite the lack of experience from your practice in some areas of the law, the number of times that you have acted almost deals with that. So you are comfortable that you have.
Indeed so, Commissioner, yes. As I indicated, there are not many, but there are fields in law which I think judges come across even when they're appointed permanently, which they don't have experience and I will learn from that. And again, coming back, I'm not looking for excuses, but in the Free State we are very limited to certain fields, especially constitutional law, because there are not a lot of constitutional matters. But as far as employment law labor law is concerned, and administrative, I can learn that.
Chief Justice, it's because of this response that I then have to ask the question that I needed to ask,
Okay.
which is this, Advocate Hefer. As you know, Section 39(2) of the Constitution enjoins all courts, when interpreting law or developing the common law and or customary law, to give effect to the purpose spirit of the Constitution. I imagine you are aware of that. And what I wanted to ask you is, while acting as a judge and in some of the matters, have you done so? And if so, could you just give us examples of those cases where you have done so?
The first, yes, thank you, Commissioner. The first one I can recall is indeed the one of the Kopanong municipality regarding the pension fund money, which was not paid out by the municipality. Then I took into account the rights of the citizens of the towns concerned in terms of the constitution and what they're entitled to. That is what I can think without looking at the judgments at this stage.
Thank you, Chief Justice. Thank you, Advocate Hefer.
Thank you, Commissioner.
Thank you. Commissioner Baloyi.
Thank you, Chair. Good morning, Mr. Hefer.
Good morning, Commissioner.
Mr. Hefer, at page 10 of the questionnaire, and in particular paragraph 6, if you have the questionnaire in front of you, where you're asked about your appearances. Do you appear in court? And this is where the court experience issue comes in. You have ticked the box so you had the option of frequently, not at all, and then you've ticked the box occasionally.
That is correct, yes.
And maybe before I ask my question, let me first make an effort to dispel the impression that people don't get appointed because they are required to have served a certain number of times as acting judges. There's no such. The question behind that question, what it is to test your experience. That's what that question is about. Yes.
Thank you.
So it's not a number of years. Now, you've answered that you appear occasionally, and you say 2 civil trials on average and 1 opposed motion per term, right?
That is correct.
And then on occasion, once or twice a year, I appear in civil appeals. So there's very little court appearance as counsel, very, very little. And that also manifests itself in the 19 years of your practice, you don't have reported judgments, right? That manifests there.
Yes.
Okay. And to the extent that you have grown confident to apply, as I have understood your earlier answer, it is because you have now acted for a certain number of weeks.
And coupled with my experience as senior counsel as well, yes.
Okay. And as senior counsel, you mean since you were called to Silk in 2019?
And even before that, Commissioner, yes. I would say because, as I indicated, I applied for Silk when I noticed that there was more difficult matters, if I can call it like that. But as just to take it further, again, as in any other division, the number of matters which senior counsel, especially senior counsel and senior junior counsels are involved in, are sometimes very limited.
Yes. Well, the only conversation I'm having with you really is, do you accept that court appearances as counsel are very critical to gaining the experience for you to sit as a judge?
Indeed, so yes.
You accept that,
Yes.
and that you really have a positive that there's very few, on your own account, you infrequently appear in court.
Well, if I just can put it in perspective, currently, yes, it is a situation since I've taken Silk,
Yes.
but it was not the situation previously.
Yes.
It has been more.
Okay, all right. The second issue is in the comments from the bar count, your bar, they in paragraph 4 rather, on page 3, they talk about your commitment to values of the Constitution. Now, do you confirm that's a description of you?
Indeed, yes, Commissioner.
How does one see that in your judgments? You've had the conversation with Ms. Pillay about issues of transformation. I'm having a different conversation. It's about in your judgments, you've earlier on in an answer to a question, you haven't done constitutional matters. You've tried to read articles. How do we as a JSC see in your judgments that you are committed to the values of the Constitution, whatever that means. We don't have sufficient time to discuss what does it mean when you say commitment to values of the Constitution. But where do I see that in the judgments?
Commissioner, yes. If I can think of my judgment in general, I did not refer, quite rightly said, I did not refer to the Constitution that many times, but again, I will do so. Well, I would have done so in the past, and will do so in the future as well, as far as the opportunity presents itself, as far as it is necessary with respect. If it's not necessary, and you want to, very often, if I may say so, very often we find in trials or applications, if you don't have anything else to fall back on as far as the merits or the technicalities of a matter is concerned, you fall back on the Constitution, which very often is very helpful. Now, in all these particular instances, with respect, I did. It was quite straightforward, if I must say so. I don't want to say to say that you must read between the lines that I did apply the Constitution, but as far as possible, I will do so, and I will have in the back of my mind it was still there.
Okay, CJ, if I could just clarify that what I was asking really, because I think Mr. Hefer misunderstands me. I'm not making the point if we are to accept as the JSC that you are committed to the values of the Constitution, it's not anything that we can distill from your judgments.
That is correct, yes.
Okay.
But as I say, if I may, I haven't referred to that because I didn't deem it necessary.
All right. Thank you, CJ.
Thank you. Mr. Hefer, that it does also concern me that after so many years in practice, you say there is only, if I understood you correctly, only one reported case in which you were involved. I heard you correctly.
That is correct, yes, yes.
Yes, and that's after, what did you say, 32 years of practice, 31 years?
30 years.
30 years of practice. Yes. We had here some candidates on Monday who were candidates for the Constitutional Court. One candidate who also appeared before us in October had been in practice for, I think, 26, 27 years or so before he went onto the bench. And the list of reported cases in which he was involved, I can't remember the number, but it was pages and pages. I would not be surprised if it was over 100 reported cases. Sorry?
It was 350.
And there are others. They may not. Their cases, reported cases, may not have been 350, but much more substantial. Even those who would have done much fewer years than yourself.
Yes.
So it's quite concerning. It's a question of what it says about you in terms of experience, in terms of maybe the types of cases that you get involved in, but the gap seems to be just too huge. You acknowledge that?
I acknowledge that, Chief Justice, yes.
Okay, all right. We have come to the end of this interview. I thank you once again for availing yourself, Mr. Hefer.
Thank you, Chief Justice.
Sorry, Chair.
Oh, is there
Chair,
another?
Yeah, I think.
Oh, I'm sorry. I'm sorry.
Commissioner Breitenbach's hand was up first.
I'm sorry. I didn't see it. I nearly overlooked you. Sorry, Mr. Hefer. I gave you hope that you are about to get out of that hot seat, but I need to give commissioners who are attending virtually an opportunity. Commissioner Barnard, I'm terribly sorry. Yes, please, you can put your question.
Thank you, Chief Justice. Advocate Hefer, would you agree that when exercising discretion, the way the court indicates to parties or the public or the reader that such discretion is not exercised arbitrarily is to indicate the actual facts on which it has relied in exercising that discretion? Would you agree with that?
I agree with that, yes, Commissioner.
Okay, so with this in mind, if we can look at that Kopanon judgment that you referred to, and specifically paragraph 52 on page 45 of the marked bundle, or the paginated bundle. Yeah, so where you exercise your discretion against the punitive cost order, and then you motivated by saying that although very similar, the facts differ from those in Tabankulu matter. Unfortunately, the reader now doesn't know in which way you say that the facts are similar and in which way you say that they differ. Would you not think that in a judgment like this, something more is required here?
Commissioner, yes, I will agree with you. It might have been more. It might have been better to refer to in which sense it differs, but I was just of the opinion because it differs, and referring to it at that stage, in my judgment, was enough.
Thank you very much.
Thank you, Commissioner Barnard. Is there another commissioner attending virtually who wishes to put a question?
Please, Chief Justice, it's Glynis Breitenbach.
Yes, please go ahead, Commissioner.
Thank you, Chief Justice. I must declare up front that I have known Mr. Hefer for many years. Good morning, Mr. Hefer.
Good morning. Morning.
Glynis is fine. I have one short question. In a criminal matter, how would you evaluate the admissibility of tainted evidence?
Of which evidence, Commissioner? Sorry?
Tainted evidence.
Tainted evidence.
Tainted evidence in which I don't quite understand the evidence, the question, Commissioner.
In a criminal trial?
Yes.
How would you evaluate the admissibility of tainted evidence?
I will still consider the credibility of the witnesses, and then I will deal with the fact in which regard it was tainted. If I can answer you, if I understand your question correctly, Commissioner. Otherwise, if I'm convinced that it was tainted, of course it will be rejected as evidence.
Thank you very much. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Shabangu, have you got any questions? Shabangu Mdawe.
Morning, CJ. And CJ, my questions have been covered. Thank you.
Thank you very much, Commissioner. Thank you. We have come to the end of the interview. If you have 2 or 3 points, Mr. Hefer, that you want to particularly emphasize to the commissioners to bear in mind when they consider your candidature, you may do so. I give you 3 minutes to do that. But if you feel that all issues have been dealt with sufficiently, that is also acceptable.
Thank you, Commissioner. I don't have anything else to add, and I thank you for the opportunity as well.
Thank you very much. Once again, thank you for availing yourself.
Thank you.
You are now excused.
Thank you.
Thank you.